नमस्कार मेरा नाम संजय चतुर्वेदी है and today we are going to speak on comparative study of Indian Evidence Act 1872 with Bhartiya Sakshya Adhiniyam 2023. Indian Evidence Act have almost 1.5 century have actually dominated and been referred by in various courts from small causes court to Supreme Court of India. The Indian Evidence Act from the age of the act we needed very badly some definitions to be incorporated, and when where there is an environment such as digital environment is taking shape in the country, the digital data, and we have all gone into UPI payments and all those other things. Various courts are taking we see the video conferencing pleadings and appearances, so that the new uh, Bhartiya Sakshya Adhiniyam, I will call it BSA 2023, been enacted very recently. I'm giving you some very quick comparative study on the Indian Evidence Act and BSA. See, for the first time, what is the objective of the BSA was that the need and the thirst area was that the lawmaker felt, and in the legal fraternity also, because the growing need of recognizing the evidence more on the digital aspect of a document was needed. So the objective, very specifically, the BSA have said is this, that the law of evidence previously falls in the category of adjective law that defines the pleadings and the methodology by which the substantive or procedural law are operationalized. The existing law does not address the technological advancement undergone in the country during the last few decades. Now, this is the objective, and in the process, what the definition of a document, very specifically, I'm going section by section also for very quick reference only, though it is very initial comparative study. I will be coming in a detailed video on the various new sections which has been incorporated in BSA. But today we are going very quickly just for a glance that what exactly is the difference. Now the BSA is also to provide is that it provides that the evidence includes, very importantly, the evidence includes any information given electronically which would permit appearances of witness, accused, experts, and victims through electronic means. Now, these are the very basic objective in the BSA. Further, it says that it provides for admissibility of an electronic or digital record as evidence having the same legal effect, validity, and enforceability as any other document. So the document definition of a document is enhanced, and the digital aspect of a document, and I will read some few very important words which has been incorporated in the definition. Further, the objective it says that it seeks to expand the scope of the secondary evidence to include copies made from the original by mechanical process, copies made from a compared with the original counterparts of documents as against the parties who did not execute them, and oral accounts of the content of a document given by some person who has himself seen it, and giving matching hash value of original record will be admissible as proof of evidence in the form of secondary evidence. It seeks to, and further it says that it seeks to put limits on the fact which are admissible and its certification as such in the courts. The proposed bill introduces more precise and uniform rules of practice of courts in dealing with facts and circumstances of the case by means of evidence. Now, I'll just quickly glance on what are those sections and comparatively with Evidence Act have been changed or incorporated. Now, very importantly, one subsection 2, which was very new section which has been incorporated, that I'll just read the section for you. The subsection 2 of section 2 of BSA provides that the words and expression used herein and not defined in the Information Technology Act 2000, Bhartiya Nagrik Suraksha Sanhita of 2023 and Bhartiya Nyaya Sanhita 2023 shall have the same meaning as assigned to them in the said Act and Sanhita. Now, what is the repercussion of this? I will just read some few sections which are been actually introduced and modified, some enhancement of the definitions and some editing and modification of the definitions are being done. Very quickly, section 1 says that it is for in the Evidence Act, it says that entire India, that this word is been removed from the BSA, and the word definition of India given in section 3 of the Evidence Act also is also omitted. The possible reason for such omission is that any stipulation that the BSA extend to the whole of India and would call into questions the admissibility of evidence digitally generated outside the border of India. So the limit is not just Indian border. The BSA will see that whatever the evidence generated even out of India digitally and which is having an impact in the Indian soil, then these are all subject to the Indian courts and we can try that. Now, some changes which section 1 subsection 1D of the BSA, which was actually in section 3 para 5 of the Evidence Act, now it is in section 2 subsection 1 subsection D, that is the document which I am talking about. Now the document, very interestingly, just I'll read from few proviso of the section and then we have a comparative analysis on this. Section 1 subsection section 2 subsection 1 subsection D of BSA gives a new definition of the word document which is compatible with the modern digital era. Now see, since the transactions, process, dealings and other things are only not confined to documents which was there in section 3 para 5 of the old Evidence Act, the BSA has now section 1 subsection 1 and further subsection D have actually expanded the definition and which includes the digitalization of the document. And what are those digitization is having a very comprehensive definition which I'll read for you. The new definition specifically includes electronic and digital records within the scope of the term document. The 5 statutory illustrations in the old definitions have been retained. The new definition gives a 6th statutory illustration, number 6, which clarifies that an electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, website, locational evidence and voicemail messages stored on digital evidences or devices are documents. So the even locational evidences, like when the police traces a person that this is a location was last traced on either through mobile device or some other device or the GIS mapping system, then the consequential evidences are being established and even the messages and websites are also being included. Now further, under the new definition to qualify as document, or documentary evidence, it is not necessary that the matter be expressed or described upon any substance by means of letter, figure, or mark only. So it is not just confined to letters, figures, or marks, but it is also digital records like voice, videos, any other expression on the digital format. Now, what are those formats? Any matter which is otherwise recorded upon any substance by any other means will also qualify as a document and documentary evidence. It appears that video recording on mobile phone would qualify as documentary evidence as it is otherwise recorded upon any substance by any other means. So even the recording made on the mobile phone is also tantamount to the uh, evidences. Now, what are those digital records? And then we are going to, have a very comprehensive analysis of the act in some other video. But I'll just conclude on just this note that electronic digital records are under the new definition of evidence in section 2, subsection 1, subsection E of the BSA. Statements, including statements given electronically, are to be treated as evidence as well as oral evidences. These, this is a logical corollary to section 530 of the Bhartiya Nagrik Suraksha Sanhita, and which providing for examination of complainants and witnesses in electronic mode by use of electronic communication or by audio video electronic means, that is the right now video conferencing. Under Evidence Act, only electronic records were treated as documentary evidence, and there was no expression mention of digital records in definition of evidence under the Evidence Act. Now, under Section 2, subsection 1, subsection E of the BSA specifically includes electronic or digital records as documentary evidences. Now, Evidence Act needed such badly needed definitions of the documents, which is now expanded, enhanced, and I believe that in the coming years, this particular act, the BSA, very specifically, those who have actually gone into, creating. So when they are, we know that the white collar crimes is in offing, the frauds, and these are things are making the evidences to book them and to give them their dues is was needed, and sometimes our courts were having helplessness when the definition was confined to only documents, and now the definition of the documents are released. If you have any questions, please do just put it in the chat box down there, or in the comment box. I'll be much uh, happy to answer you all your questions. In the other videos, I'm going to cover the other two acts also, including that we will going to have a very detailed commentary on the new BSA Act. Till then, thank you very much for listening.